The job that I was working, I lost, and so my income has declined, and I'm asking for an adjustment in the child support amount.
Solely based on the fact that she's not working, I don't think is fair and equitable at this time.
Child support, is that correct?
Correct.
Can you please state the basis for your motion regarding support, ma'am?
The job that I was working, I lost in April, and so my income has declined, and I'm asking for an adjustment in the child support amount due to the changes in income.
Any other proposed changes you're requesting, ma'am?
This is a fascinating moment. Notice how the mother isn't just asking for a reduction in child support. She's also slipping in a request to increase her overnight custody. Courts pay close attention to moves like this because increasing overnights often shifts the financial balance between parents. More overnights can mean less child support from one side and more responsibility for the other. But the judge doesn't seem convinced. He even hints that the proposed change might not make much of a difference in the overall support amount. So the real question becomes, is she doing this purely for the children's best interest? Or is this a strategic move to ease her financial pressure?
I don't know if this is something I could do at the same time, but I would like to also adjust the overnights to increase, to just adjust to what we have been doing the past couple years. Due to summer performance schedules, the girls have spent a couple extra nights with me. So it would be 4 additional for Effie, our oldest, and 10 additional for Amelia, the youngest, per year.
Okay, that may or may not make much of an impact as far as that little change of overnights, but I will see what Mr. Jarvie's position is regarding the overnights.
Okay.
Your motion also referenced something about childcare.
Oh, they don't need childcare payment anymore because they come home to me after school. So there's no childcare after school anymore. So I wanted that removed, yes.
And ma'am, are you working then at this time or not working?
Here's where things get tricky. She's not working right now, but instead of taking an available job, she's chosen to go back to school for certifications. On the surface, that sounds admirable. She's trying to improve her future. But in family court, this is often seen as voluntary underemployment. That means the judge can impute income, basically treating her as if she's still earning what she used to make, assuming she's capable of doing so. The idea is to protect the children's financial stability, because support shouldn't drop just because a parent decides to hit pause on their career. So here's the big question. Should courts allow parents to take that time to study and invest in their future? Or should financial responsibility always come first?
I've been looking for a job all summer, and right now I'm looking into gaining a certificate so that I'll have an additional endorsement either for special education, autism spectrum disorder, or speech language and impairment, or I'm also looking into a K-12 education administration program. So because there's no jobs available in my expertise, my certification within 100 miles, and I wasn't able to apply to the ones that are outside the area because I asked and he said we couldn't move over 100 miles. So I may be becoming a student as soon as in a couple of weeks to gain a certification. So that's additional graduate certificate, so about 21 extra graduate level credits.
The judge lays down a key principle here. Until she secures another job, the court will treat her as if she's still earning her previous salary. That might sound harsh, but it's designed to prevent one parent from dodging work while pushing the financial weight onto the other. At the end of the day, family court is all about stability for the child, not convenience for the parents. The legal takeaway here is simple but powerful. Courts don't just look at what you're earning now. They look at what you could be earning.
And I understand that you're not working, but the court has the obligation to consider whether or not somebody could be working, and you can do what is called imputing income to somebody.
Okay.
If you got a different job, then we would take into consideration what that different job is. If it is a lower paying job, if you're not able to obtain the same type of paying job,
right,
I would certainly consider changing what your monthly amount is. But until we know what you're able to obtain, the court typically goes off of what somebody was previously making, as that is shown as a history of the ability to make that amount. So if you aren't currently working, we don't have the ability to have another job to consider for payment.
My-
At this point, I'm not really inclined to change the income until we know what your next job would pay, whether it's more or less of what you were previously making. As to the childcare, we can certainly lower that. And then you also raised whether or not there were changes in the income for Mr. Jarvie. Is that correct?
Yes, I'm not aware of his income, but I would assume that pay scale's gone up for the teaching schedule.
Mr. Jarvie, would you?
Now we hear the father's side, and this is where things start to shift. He openly admits his income has gone up a bit and even agrees to increase support based on that. But then, he pivots. He points out that the mother has passed up job opportunities, like substitute teaching roles, suggesting she's not exactly eager to work that I am doing so. He flips the script, from defending himself to questioning her effort and credibility. And that's a powerful move in family court. Judges don't just look at income, they look at effort, consistency, and intent. So the real question becomes, has she done enough to prove she's trying? Or is this request more about convenience than necessity?
Full truth and nothing but the truth.
Yes.
Anything you want to say in response to her motion regarding child support?
During the summer and early fall, I did forward to her some job opportunities, which I think a lot of them she applied for. I also encouraged her to be a substitute teacher. They're very desperate to find teachers, especially in Gaylord schools where I work. They have a shortage there. She chose not to pursue that as an option. And she could pretty much work every day doing that type of teaching work. In regards to asking me for more money, yes, I do make more than I did 3 years ago. I can confirm that. It's not a whole lot, but it is a little bit. So I would be willing to increase what I pay based on that increase. Other than that, I believe Miss Aber needs to get a job, some kind of job. She doesn't seem to be real eager to pursue anything right now in terms of work. And so asking me for more money solely based on the fact that she's not working, I don't think is fair and equitable at this time. So that's kind of my view on things right now.
This back and forth over overnights is a classic custody tug-of-war. The mother insists she's had more time with the kids. The father fires back, saying it all evens out. But without records, it turns into a he-said-she-said stalemate, and judges hate ruling on guesswork. They want proof, calendars, text logs, parenting schedules, something solid to stand on. In this case, neither side brought the receipts, and that makes it almost impossible to verify who's right. That I in family court. Documentation speaks louder than emotion or memory.
The overnight number isn't accurate. What is your response to that?
The overnights have been adjusted throughout the year, back and forth. There's some nights, and she didn't mention, where I was hosting one or two of the kids. Either they were sick or something came up with the schedule. So the nights have gone back and forth. I don't really believe that there's a huge difference in the number of nights throughout the year. Again, I don't have a record of that.
All right, thank you. All right, ma'am, is there anything you want to say before I make a decision?
Ma'am.
Yes.
I did. I applied for all the jobs. I interviewed for the jobs. I actually interviewed for an assistant program at Gaylord Community Schools, and they were extremely rude to me at the interview, and they did not offer me the assistant job when I went into...
The ruling comes down with precision. The judge agrees to remove child care costs since the kids no longer need after-school care. A small win for the mother. But she doesn't get everything she wanted. Her request to lower her imputed income, denied her push for more overnights, also denied. The father's slight pay increase will factor into recalculated support order. But overall, the court makes one thing clear. Both parents stay accountable. In the end, the judge chooses stability for the children over flexibility for the parents. That's the heartbeat of family law. Fairness rooted in consistency.
Interview for that job. So that's why I haven't gone there yet. It is on my list of places to look into for a substitute position, but right now I'm also looking for a way that I can get the same amount of money that I had been getting instead of going straight to being a substitute teacher.
Okay, thank you. All right, well, given that information as to the motion regarding support, I will indicate a new support recommendation would be prepared based on any changes to the defendant's income. So the front of the court will send you the appropriate financial paperwork to complete that. Ms. Hebert has lost her job, is not currently working. At this time, though, I would still continue to impute her income at her last income. And obviously, if she does get a different job, then the matter could be brought before the court again if that job is paying less money than it was previously calculated at, and the court would consider adjusting the income for her at that time. As to the overnight issues, it does not appear there has been a significant change in the number of overnights the parties are exercising, so I would deny the request to change the overnights. And given Ms. Hebert's testimony that the children are not receiving childcare anymore, that should be eliminated from the next child support recommendation. Ms. Hebert, do you have any questions?
I do not.
All right, thank you. Mr. Driver, do you have any questions, sir?
No.
So, here's the takeaway. The mother's request for lower support fell flat because the court decided to impute her old income, holding her accountable until she proves she's truly earning less. Her push for more overnights? Denied. No evidence. No change. Still, she did score a small win by removing child care cost from the equation. Meanwhile, the father admitted his income went up and even agreed to pay more. A move that likely earned him serious credibility with the judge. At the heart of this case lies one powerful truth. In family court, financial responsibility isn't just about what you earn. It's about what the court believes you can earn. If you found this case as fascinating as we did, hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.